The only mechanism that can properly change this clause is the primary constituent power. Second example, for symmetrical reasons, is also drawn from Article 2 of the Constitution, which reads, general rules of international law shall form part of the law of Kenya. This clause is also part of the supremacy of the Constitution and forms the basic structure of the Constitution. The spirit or core meaning or value of that clause cannot therefore be changed without involving the primary constituent power. However, its precise formulation in the Constitution is not unamendable. It may be amended, for example, to clarify what is meant by the term general rules of international law. For example, an acceptable clarificatory constitutional amendment might seek to replace the term general rules of international law with the term customary international law, which is a more familiar law in the discipline of public international law. Such an amendment can be achieved through the secondary constituent power under Article 255 of the Constitution. The third example may suffice to make the concept clear. Article 89(1) of the Constitution provides as follows: there shall be 290 constituencies for purposes of election of the members of the National Assembly provided for in Article 97(1)(a). While the foundational structure of Chapter 7 of the Constitution, where Article 89(1) is located, is part of the basic structure of the Constitution, and its core meaning and import cannot be changed without utilizing the primary constituent power, the exact number of constituencies stipulated in Article 89(1) can be increased or reduced either through secondary constituent power or constituted power. Therefore, Article 89(1) is not unamendable, though the core import and spirit of Chapter 7 of the Constitution is considered unamendable as part of the basic structure. In the same vein, while Article 89(1) is amendable utilizing the secondary constituent power or constituted power, Article 89(2) through to Article 89(12) of the Constitution are amendable as discussed later in this judgment. This is because a correct reading of the text, history, functions, and constitutional structure gives the unmistakable conclusion that Kenyans intended to elucidate the specific principles and processes, the process of the limitation of electoral units from revision without triggering the primary constituent power. I now hand over to my brother Justice Ngaah to continue.
Thank you, Judge. Now deal with the question of the constitutional remit of popular initiative. It is important to set out at the outset the constitutional provisions dealing with the amendments of the Constitution. The power to amend the Constitution is prescribed in Articles 255 to 257 of Chapter 6 of the Constitution as follows. We have reproduced those articles in our judgment. In order to properly understand these articles, it is important to retrace the genesis of the said provisions in order to place them in the historical context. We are enjoined, as was held by the Supreme Court, in the matter of the principle of gender representation in the National Assembly and the Senate, Advisory Opinion Application Number 2 of 2012, and as set out in Part 4.1 of this judgment, to take into account the agonized history attending Kenya's constitutional reform, a view reiterated by the same court in the matter of the Kenya National Human Rights Commission, Advisory Opinion Number 1 of 2012. We have quoted the pertinent excerpt in our judgment. In the CKRC final report, it was acknowledged that apart from Parliament, there was a need for the people to exercise their constituent power in any matter relating to the amendment of the Constitution. It was therefore recommended that citizens and the civil society be enabled to initiate constitutional amendments through a process called, unquote, popular initiative, unquote. Accordingly, it was recommended that the Parliament enacts a Referendum Act to govern the conduct of referenda in the country. However, in the guide draft, no provision was made for amendment by popular initiative, and only the provision for amendment by Parliament was made. Due to some contradictions and duplications noted in the guide draft, the same was revised and the zero draft was generated. This was similarly revised to give way to the revised zero draft to remove duplications and inconsistencies, standardize language, present material in a logical order, and supply necessary provisions to bridge gaps, while at the same time maintaining the principles on which the zero draft was based. The issue of amendment of the Constitution appeared as Article 346 in Chapter 19 of this draft, titled Amendment by the People, and of importance was Clause 1, which stated as follows: an amendment to this Constitution may be processed by a popular initiative signed by at least 1 million citizens registered to vote. The said clause was retained almost verbatim in the subsequent Bomas draft. Article 304 of the Bomas draft was also entitled Amendment by the People. However, in the subsequent revision in the Wako draft, though the provision on popular initiative was maintained, this time under Article 283, titled Amendment through Referendum, Clause 1 thereof was reworded as follows: an amendment to this Constitution may be proposed by a popular initiative supported by the signatures of at least 1 million registered voters. As narrated above, the Wako draft was rejected at the referendum in 2005, after which the process resumed in 2008, following the adoption of the Constitution of Kenya Review Act in December 2008. That act incorporated the views of the court in the Timothy Njoya case that the sovereign right to replace the Constitution with a new Constitution vested collectively in the people of Kenya and shall be exercisable by the people of Kenya through a referendum. As discussed above, in this fresh impetus, it was agreed to harmonize all the previous drafts with only issues identified as contentious being reopened for discussion. After the establishment of the Committee of Experts in February 2009, the Committee of Experts prepared the revised harmonized draft, which was handed to the Parliamentary Select Committee on Constitutional Review. In this draft, the clause featured under Article 238, titled Amendment by the Popular Initiative, and the relevant clause was worded as follows: an amendment to this Constitution may be proposed by a popular initiative signed by at least 1 million registered voters. What comes out from this historical discourse is that the popular initiative clause fell among the non-contentious issues, as it features substantively unaltered in all the draft of the Constitution. We also note that the drafters of this clause intended that it be invoked by the citizens, registered voters, and civil society groups, as opposed to government institutions and officers. Whereas the civil society groups did not find their way into the final documents, the originators were retained as the registered voters, thereby maintaining the original intention that the power to initiate constitutional amendment by way of popular initiative was exercisable only by the voters. The clause, as it appears in our Constitution, bears resemblance to various clauses in constitutions of other countries on this issue. These countries include Switzerland, Moldova, Venezuela, and Liechtenstein. We have reproduced what it is explained to be in Wikipedia. Going by that definition and comparative jurisprudence, amendment of the Constitution through popular initiative cannot be undertaken by the government when it is the same entity that is being compelled to undertake the amendment, and in default, the amendment to be subjected to a referendum. It is therefore clear from our constitutional scheme that there are two ways in which a constitutional amendment can be initiated, either by parliamentary initiative or by popular initiative. The said provisions are in sync with the provisions of Article 1, Sub-Article 2, or Clause 2 of the Constitution, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Since Article 2, Clause 2 of the Constitution, since under Article 2, Clause 2 of the Constitution, no person may claim or exercise state authority except as authorized under this Constitution, it necessarily follows that, subject to what we have stated elsewhere in this judgment as regards the role of primary constituent assembly, there is no other constitutionally permissible avenue available to any person to initiate a constitutional amendment save by the prescribed ones, parliamentary and popular initiatives. We shall come back to this issue in due course. We now proceed to deal with the question whether the Constitution Amendment Bill falls within the initiatives contemplated in Chapter 16. It is not in doubt that via Gazette Notice number 5154, the President set up the task force on building bridges to unity advisory. As outlined above, the mandate of the task force was to outline the policy, administrative reform proposals, and implementation modalities for each identified challenge area, and conduct consultations with the citizens, the faith-based sector, cultural leaders, the private sector, and experts at both the county and national levels. Whereas one may well argue that in setting up the task force, the President was undertaking his constitutional mandate under Article 131, Clause 2C of the Constitution, which enjoins him to promote and enhance the unity of the nation, his subsequent action is, however, the subject of controversy. Pursuant to the report of the task force via Gazette Notice number, Special Issue number 264, dated 10th January 2020, the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report was established, comprising of the same members of the task force. The committee's role was expressed to conduct validation of the task force report through consultation with citizens, civil society, the faith-based organizations, cultural leaders, the private sector, and experts, and to propose administrative policy of constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report, taking into account any relevant contribution made during the validation period. The steering committee submitted the report to the President on 21st of October 2020, consisting of a raft of proposals on constitutional and legislative amendments, as well as draft constitutional amendment bill, draft legislative bills, administrative measures, and other recommendations. With that report, the seed for constitutional amendment process was sowed. From the foregoing, it is clear that the Constitutional Amendment Bill is an initiative of the President. It cannot be otherwise, since the task force was set up courtesy of his initiative, and the subsequent steering committee was tasked with the implementing the task force report, and the membership of the two entities remained the same. Under Article 131, Clause 1b of the Constitution, the President exercises the executive authority of the Republic with the assistance of the Deputy President and Cabinet Secretaries. Under the Constitution, the President is not a member of Parliament and therefore cannot directly purport to initiate a constitutional amendment pursuant to Article 256 of the Constitution. This is because under Article 94, Clause 1 of the Constitution, the legislative authority of the Republic at the national level is vested in and exercised by Parliament. It follows that the President has no power under the Constitution as the President to initiate changes to the Constitution under Article 256 of the Constitution, since Parliament is the only state organ granted authority by or under the Constitution to consider and effect constitutional changes. The President, if he so desires, can, however, through the Office of the Attorney General, use the parliamentary initiative to propose amendments to the Constitution. As we concluded above, both a textual analysis of our Constitution and a historical exegesis of the clause on popular initiative makes it clear that the power to amend the Constitution using the popular initiative route is reserved for the private citizen. Neither the President nor any state organ is permitted under our Constitution to initiate a constitutional amendment using popular initiative. Beyond the text of the Constitution, there is another reason it is impermissible under our Constitution. In our view, to permit the President to initiate such amendments through a popular initiative and then sprint to the finishing line to await and receive it and to determine its ultimate fate would have the effect of granting to him both the roles of the promoter and the referee. This is because Article 257(5) of the Constitution provides that if a bill to amend this Constitution proposes an amendment relating to a matter specified in Article 255(1), the President shall, before sending to the bill, request the IEBC to conduct within 90 days a national referendum for approval of the bill. In other words, Article 257, Clause 5 of the Constitution arguably gives the power to the President to determine whether or not a referendum is to be held. In circumstances where the President, whether in his official or personal capacity, is the promoter of the amendment bill, his role in determining whether or not the bill is to be subjected to a referendum may well amount to a muddled up conflict of interest. The President cannot be both player and the umpire in the same match. Next is the question whether the Constitution Amendment Bill is a state-sponsored initiative and whether it qualifies as a popular initiative as envisaged under Article 257 of the Constitution. From the discussion above, it is clear that the initiative to amend the Constitution was conceived after the task force presented its report to the President, who then appointed the steering committee. That process was spearheaded by the President as the Chief Executive of the Republic of Kenya, who then appointed the steering committee and included in its terms of reference the following term, quote, to propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report, taking into account any relevant contributions made during the validation period, unquote. It has been argued that the President was acting in his personal capacity and not as the Chief Executive of the Republic of Kenya. This argument is, however, betrayed by the very fact that the BBI Steering Committee was established via a gazette notice, an official publication of the Government of the Republic of Kenya, and its report was addressed to His Excellency the President of the Republic of Kenya and the Commander-in-Chief of the Defense Forces, Honorable Uhuru Kenyatta, CGH, unquote. More importantly is the question whether the President can, under the guise of being a private citizen, exercise the powers of amendment reserved under Article 257 of the Constitution. A textual reading of Article 1, Clause 2 of the Constitution, which I've referred to above, reveals that the powers thereunder are exercisable either directly or through their democratically elected representatives. The employment of the phrase either directly or is a clear manifestation that the drafters of the Constitution intended that there be a distinction between direct and representative exercise of sovereign power. This court, in interpreting the Constitution, must do so holistically, as we have explained above, as was held in the case of Tinyefuza versus Attorney General. In our view, in interpreting the Constitution holistically, as we are enjoined to do, Article 1, Clause 2 must be read together with Articles 256 and 257 of the Constitution. When one considers these provisions together, the only reasonable conclusion is that the Article 257 of the Constitution is reserved for situations where the promoters of the bill do not have a recourse to the route contemplated under Article 256. Our view is in tandem with the historical genesis of the provisions we have set out herein above. In other words, the Article 257 route is meant to be invoked by those who have no access to Article 256 route. Those who have access to Article 256 route are therefore barred from purporting to invoke Article 257 route. There is no doubt that the President, if he intends to initiate a constitutional amendment, may do so through the aegis of Parliament. It follows that since the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force was a brainchild of the President, it has no longer standing in promoting constitutional changes pursuant to Article 257 of the Constitution. It is our view that a popular initiative, being a process of participatory democracy that empowers the ordinary citizenry to propose constitutional amendment independent of the lawmaking power of the governing body, cannot be undertaken by the President or state organs under any guise. It was inserted in the Constitution to give meaning to the principles of sovereignty based on historical past, where the reservation of the power of amendment of the Constitution to the elite few was abused in order to satisfy their own interests. The respondents and some interested parties have taken refuge in the fact that there were previous initiatives sponsored by the state in 2005 and 2010 to amend the Constitution as a basis of justifying the role of the state organs in the popular initiative. It is important to note that the previous initiatives were undertaken under the retired Constitution. At that time, there was no provision for two initiatives as provided under the current Constitution. The provisions of two distinct initiatives under the current Constitution lends credence to the fact that the two avenues are distinct and ought not to be muddled up by creation of a hybrid initiative unknown to the Constitution. Therefore, it is our finding that the popular initiative as a means to amend the Constitution under Article 257 of the Constitution is a power reserved for Njiku. Neither the President nor any state organ can utilize Article 257 of the Constitution to amend the Constitution. Now, in this part of the judgment, we now turn to the various questions raised challenging the legality of the entire BBI process, from the establishment of the steering committee to the implementation of its finding and report through the Constitutional Amendment Bill and associated proposed legislations. After considering the consolidated petitions, the responses thereto, and both oral and written submissions in support of and in opposition to the consolidated petitions on the specific issue of the legality of the BBI process, we have come to the conclusion that there is not much of a dispute on what, no doubt, are the facts material to the determination of the questions presented. To begin with, it is not in dispute that Mr. Joseph K. Kinyua, who is the head of the public service, informed the public that His Excellency Honorable Uhuru Kenyatta, the President of the Republic of Kenya, had established a task force known as the Building Bridges to a United Advisory Task Force, comprising of 14 members and 2 joint secretaries. It is also not in dispute that this information was relayed to the public through a government publication, being Gazette Notice number 5154 of 24th May 2018, and which was published in the Kenya Gazette dated 31st May 2018. The terms of reference of this task force are also not in dispute and have been reproduced in this judgment. It is worth repeating them owing to their centrality in issue under consideration. We have reproduced them in our judgment. It is also not in dispute that in a special issue of Kenya Gazette of 3rd May 2019, the President published the 6th Annual Report 2018, in which he remarked as follows. We have reproduced the excerpts of the President's report in our judgment. You'll have opportunity to read it when you get the copy of the judgment. Again, it is not in dispute that in yet another Gazette notice published as special issue on 10th January 2020, number 7, this is Gazette Notice number 264, dated 3rd January 2020, the head of the public service notified the public that the President had appointed the steering committee comprising of 14 members and 2 joint secretaries whose terms of reference have been reproduced above. Now, we have had to reproduce all these Gazette notices because they, by and large, triggered the events that culminated in what turned out to be a deliberate process to amend the Constitution, and which has in turn yielded to the Constitutional Amendment Bill. The overarching question that emerges out of these undisputed facts is whether the process adopted in the attempt to amend the Constitution is consistent with the means prescribed by the Constitution to amend it whenever such an amendment is necessary. But before interrogating this primary question, there are issues that have been raised by the Honorable Attorney General, which we must necessarily be disposed of as preliminary points of law. These issues are as follows. First, whether the questions presented regarding the legality of the BBI process are sub judice. Second, whether those same questions presented are res judicata. And finally, whether Mr. Uhuru Muigai Kenyatta can be sued in his personal capacity during his tenure as the President of the Republic of Kenya. The first 2 questions are related, and perhaps for this reason, are respectively covered under sections 6 and 7 of the Civil Procedure Act. We have reproduced the 2 sections in our judgment. The rationale behind section 6 of the Civil Procedure Act is that it is vexatious and oppressive for a claimant to sue concurrently in two courts. Where there are two courts faced with substantially the same question or issue, that question or issue should be determined in only one of those courts, and the court will, if necessary, stay one of the claims. Ordinarily, it is the second suit that will be stayed. Two obvious prerequisites necessary to stay a suit under this provision of the law are: one, the matter in issue in the subsequent suit must be directly and substantially in issue in the previously instituted suit, and two, the parties in the two suits must be the same parties or parties claiming under them or litigating under the same title. The basis of the Honorable Attorney General's argument that the issues raised in the petition number 486 of 2020 is caught out by this provision of the law is High Court petition number 12 of 2020, in which one Okia Omtata Okoiti is named as the petitioner. There are 5 respondents in that petition. The first is the National Executive of the Republic of Kenya. The second is the National Treasury. The third respondent is the Presidential Task Force on Building Bridges to a United Kenya Advisory. And the last respondent is the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. Beside the respondents, 2 other parties have been named as the interested parties, and these are Katiba Institute and Muslims for Human Rights, Muhuri. The prayers sought in that petition have been reproduced in this judgment. I will not go through them. So, going by those prayers, which Mr. Okia Omtata sought in petition number 12 of 2020, there is no doubt that the matters in issue in his petition, which we will henceforth refer to simply as the Omtata petition, are covered in these consolidated petitions. However, it is also not in dispute that the consolidated petitions cover a wider range of issues than those covered in the Omtata petition, to such an extent that due to its wider scope, there would still be a need to hear and determine the consolidated petitions, even if the Omtata petition had been heard and determined. In short, while it is true that the matter in the Omtata petition is directly and substantially in issue in these consolidated petitions, the matter in issue in these consolidated petitions cannot be said to be directly and substantially in issue in the Omtata petition. On the Omtata petition, only a segment of it is. That aside, it is also clear that the parties in the two suits are different. The absence of the petitioner in the Omtata petition in the present petition stands out. It follows that the two prerequisites necessary before a court can order a stay of proceedings under Section 6 of the Civil Procedure Act have not been demonstrated to obtain, and therefore there will be no reason of staying these consolidated petitions pending the determination of the Omtata petition. We must add that even if the present suit was on all fours with the Omtata petition, the institution of these proceedings would not have been in any way fatal. The farthest this Honorable Court could go is to stay these proceedings, and staying of such a proceeding is normally necessary to avoid the trial or hearing of the claim taking place where the court thinks it is just and convenient to make the order, to prevent undue prejudice being occasioned to the opposite party, or to prevent the abuse of the process. The consolidated petitions, being wider in scope, than the Umtata petition cannot be said to be an abuse of the process. Apart from the fact of filing the Umtata petition, there is no evidence that any further step has been taken towards prosecution and determination of that petition, yet it cannot be denied that the nature of the dispute in this petition demands an expedient determination. For this very reason, we think that it is also in the public interest that these consolidated petitions be resolved at the earliest opportunity possible. Considering the progress that has been made towards its conclusion, culminating in this judgment, it could not have been held in abeyance pending the determination of the Umtata petition, whose program for determination is unknown. If anything, the determination of this suit may, in one way or the other, help resolve the Umtata petition. Related to this issue of sub judice is the question of res judicata, which, as earlier noted, is covered under Section 7 of the Civil Procedure Act. This provision of the law is based on the fundamental doctrine of all courts that there must be an end of litigation. The doctrine of res judicata may be pleaded by way of estoppel, so that where a judgment has been given, which is a matter of record, an estoppel by record arises. The rationale for the existence of the estoppel by record can be summed up in two expressions: that it is in the public interest that there should be an end of litigation, and that no one should be proceeded against twice for the same cause. Estoppel by record may take the form of cause of action estoppel or of issue estoppel. It may also be said that the cause of action has merged in the judgment. Where res judicata is pleaded by way of estoppel to an entire course of action, rather than to a single matter in issue, it amounts to an allegation that the whole legal rights and the obligations of the parties are concluded by the earlier judgment, which may have involved the determination of the questions of law as well as findings of fact. This is a form of action estoppel. Issue estoppel, on the other hand, means that a party is precluded from contending the contrary of any precise point which, having once been distinctly put in place in issue, has been solemnly and with certainty determined against him. Even if the objects of the first and second claims or actions are different, the finding on a matter which came directly in issue in the first claim or action, provided it is embodied in a judicial decision that is final, is conclusive in a second claim or action between the same parties and their previous. Issue estoppel will only arise where it is the same issue which a party is seeking to re-litigate. This principle applies whether the point involved in the earlier decision and as to which the parties are estopped is one of fact or one of law or one of mixed fact and law. The Honorable Attorney General is urging what is certainly issue estoppel. The Honorable Attorney General has not argued that this suit is res judicata as such, but that the specific question concerning the legality or constitutionality and the mandate of the BBI Steering Committee has been resolved by this court. But in the Third Way Alliance case, which is Third Way Alliance and another versus the head of public service and two others. In that case, that is the Third Way Alliance of Kenya, a political party registered under the Political Parties Act number 11 of 2011, which is the petitioner in petition number 400 of 2020 in the present consolidated petitions, sued Mr. Joseph Kinyua, the head of public service, the building bridges to a United Advisory Task Force and the Honorable Attorney General. Among us, the prayer sought in that petition was a prayer framed as follows. A declaration that the body being referred to as the Building Bridges to a United Advisory Task Force established by Gazette Notice number 54 dated 24th May 2018 is unconstitutional, illegal, null, and void. The Honorable Attorney General's argument that the constitutionality and the mandate of the BBI Steering Committee is a question that has been resolved is no doubt based on the learned judge's determination on issues surrounding this particular prayer, and therefore it is necessary to consider what the judge said in respect of this issue. So we have reproduced the excerpts of the judgment of Judge Matiwa J in that judgment, in this judgment. We must set at the outset that we are conscious that the decision in the Third Way Alliance case is cited before us not necessarily as a decision from a court of coordinate jurisdiction persuading us to take any particular position on a point of law, and from which we are entitled to depart if there are reasons to do so. Instead, it is presented in the context of a judgment in rem binding us on a specific point of law. It is from this perspective that we shall consider that decision. Of the several questions that we have been asked in these consolidated petitions, one question that was not asked in the Third Way Alliance case is whether the President can establish a committee or any other entity for that matter to initiate the change or amendment of the Constitution outside the means prescribed by the Constitution itself. To be precise, can the amendment of the Constitution be initiated in any way other than those envisaged under Article 256 and 257? As we understand it, the petitioner's case in petition number 426 of 2020 is that the BBI Steering Committee impermissibly initiated the amendment of the Constitution in the guise of an amendment by popular initiative under Article 257, when in fact it is an initiative by the President hiding behind the BBI Steering Committee. The question we are faced with is whether BBI Steering Committee, which in the petitioner's view was established with the sole purpose of undertaking an assignment that is contrary to the provisions of the Constitution, is constitutional, and by the same token, whether anything done by such committee is unconstitutional. In our humble view, the answer to this question cannot be found in the judgment in the Third Way Alliance party case, not because the court in that case was incapable of answering it, but because it is a question that was not asked and interrogated. In the words of explanation 3 of Section 7 of the Act, it is not a matter alleged by one party and either denied or admitted expressly or impliedly by the other. What is before us is a more specific question that narrows down from the question whether the President can generally form any committee of whatever form or shape on any matter to a more specific question whether he can form such a committee to initiate changes or amendment to the Constitution. This was a question not before the learned judge in the Third Way Alliance case. This is because in the Third Way Alliance case, the BBI task force did not have the mandate to initiate constitutional amendments. However, the BBI Steering Committee has, as one of its terms of reference, the mandate to initiate constitutional changes, which is the exact reason the petitioner in petition number 426 of 2020 is challenging its legality. And on that note, I hand over to my colleague. You need to finish that. Sorry. Finally, it is for the foregoing reason that we are of the firm view that we are not stopped from discussing the constitutionality of the BBI Steering Committee and its mandate insofar as the amendment of the Constitution is concerned. In other words, this issue is not res judicata.
The other question that deserves attention and which we thought should be determined as a preliminary issue is whether Mr. Uhuru Muigai Kenyatta can be sued in his personal capacity and not as President of the Republic of Kenya. This is because he is named in his personal capacity as the first respondent in petition number A426 of 2020. A straight answer to this question is found in Article 143, Sub-Article 2 of the Constitution, but which we think it is better understood in the context of the entire article, and we have reproduced that article in this judgment. A plain reading of this provision of the Constitution reveals the following. Criminal proceedings cannot be taken against the President of the Republic of Kenya during his tenure as President. As far as civil proceedings are concerned, the President cannot be sued during his tenure if whatever is in issue for is something done or not done in the exercise of powers he is clothed with by the Constitution, where proceedings, whether criminal or civil, that may be taken against the President after his tenure are subject to limitation period. Time does not run until the expiration of his tenure, and the President may be prosecuted during his tenure if the crime of which he is prosecuted is defined by a treaty to which Kenya is a party and which prohibits immunity from prosecution. This bone of contention revolves around Article 143, Sub-Article 2 on civil proceedings. Only the Honorable Attorney General submitted on this point, and his argument is that it is not that the President cannot be held accountable for his actions while in office, but that whenever he is to be sued, the proper procedure to adopt is judicial review proceedings in which the Honorable Attorney General, rather than the President, would be named in the proceedings as a respondent. The bulk of the Honorable Attorney General's submissions on this point came in the form of a reproduction of a court decision in Jarius versus Attorney General case, and we have cited the paragraphs in that decision which the Honorable Attorney General relies extensively in making that submission. It is apparent, therefore, that the Honorable Attorney General is in agreement with the petitioner in petition E426 of 2020, at least to the extent that according to Article 143, Sub-Article 2 of the Constitution, Mr. Uhuru Kenyatta is subject to civil proceedings during his tenure whenever he either acts outside the parameters of the Constitution or omits to do that which he is bound to do under the Constitution. The Honorable Attorney General's only concern is that it is his office rather than the President who should be named in those proceedings. In these proceedings, both the President and the Attorney General have been named as respondents, and therefore the question of non-joinder should not arise. The issue that has been raised by the Honorable Attorney General is that of misjoinder, that the President ought not to have been made a party to these proceedings. To begin with, it is worth noting that Mr. Uhuru Muigai Kenyatta did not enter appearance in these proceedings, and neither did he file any grounds of objection or a replying affidavit to contest these proceedings on the grounds of misjoinder or any other ground for that matter. As much as the Honorable Attorney General has come to his defense, the grounds of objection and the submissions filed by his office clearly state to have been filed on behalf of the Honorable Attorney General himself and not Mr. Uhuru Muigai Kenyatta. It could be that Mr. Uhuru Muigai Kenyatta has proceeded on the understanding that since the Attorney General, since he ought not to have been sued in his personal capacity, he need not have responded or participated in these proceedings. However, since this is the very question in dispute, we are of the humble view that Mr. Uhuru Kenyatta ought to have responded to the petition either by himself or by his duly appointed representative and contest his inclusion in this petition on any of the grounds that would be available to him. We find it a bit intriguing that the Honorable Attorney General can file documents for his own defense and proceed to argue the case for Mr. Uhuru Muigai Kenyatta. In the case of Isaac Apollo Chair versus Uhuru Muigai Kenyatta, that's a decision of this court, differently constituted. Mr. Uhuru Kenyatta had been sued together with the Deputy President and in their personal capacity. This court, Naola J as he then was, held that the Honorable Attorney General could not represent the President whenever the latter is sued in his personal capacity. This being the legal position, the learned counsel for the Honorable Attorney General could not purport to make any representation or submissions that would tend to show that he was representing Mr. Uhuru Muigai Kenyatta. Be that as it may, Order 1, Rule 9 of the Civil Procedure Rules is clear that a suit cannot be defeated for misjoinder or non-joinder, and that what the court should be bothered with is the determination of rights of the parties, the rule and the determination of the parties. We have cited the rule as it states. To the extent that this rule is applicable to the petition such as the one before this court, we can confidently say that regardless of whether or the first defendant has been properly joined to this suit or not, this court is in good stead and ideally proceed to deal with the matter in controversy so far as regards of rights to the interest parties is taken into account. And if this is the case, nothing much would turn to the question whether or not the first defendant is Mr. Uhuru Muigai Kenyatta ought to have been sued. However, there is something more the petitioners want to the court to make a specific finding on that civil court proceedings can be instituted against the President or a person performing the functions of the office of the President during the tenure of office in respect of anything done or not done in the exercise of claimed powers beyond those authorized under the Constitution, that is, for the same actions or omissions not authorized under the Constitution. Of course, it has been considered by the Honorable Attorney General that civil proceedings can be taken against the President during his tenure, except that he need not be sued in his personal capacity. For the reason, the relief claimed against him would ordinarily be a public law remedy, and therefore the appropriate proceedings would be judicial review proceedings in which the Honorable Attorney General and not the President should be named as a respondent. This is a point of departure between the petitioner in this petition and the Honorable Attorney General. It is the petitioner's view that where the President acts or omits to act in contravention of the Constitution, then he cannot be sued personally. He cannot be sued personally, but he should also be held personally responsible for any loss that may have ensued as a result of his action or inaction. It is common ground between the parties that the plain reading of Article 143 sub-Article 2 of the Constitution reveals that civil proceedings can be taken against the President during his tenure. Both the petitioner and the Honorable Attorney General are in agreement that if the President flouts the Constitution in one way or the other, then civil proceedings against him during his tenure would be quite in order. The only bar to such proceedings is if whatever the President is sued for having done or omitted to do was done or omitted in exercise of the powers conferred upon him by the Constitution. We think this is apparent from sub-article 2 of Article 143. We have again stated what that sub-article says. If it is agreed that civil proceedings may be taken against the President, there is nothing in law that suggests that only a particular form of civil proceedings would be preferred to the other. To be precise, there is no legal basis for the Honorable Attorney General's argument that whenever the President is sued in civil proceedings, the only means by which those will be taken is by an application for judicial review. The petitioner's action is based on what he believes to be a violation of the Constitution by the President, and we are of the view that there would be no better means through which his grievances can be addressed than through a constitutional petition, such as the one he has brought before this court. It must be noted that owing to their history, proceedings by way of judicial review are limited in the nature of reliefs that a court may grant. Not so with the constitutional petition. In any event, according to Article 23, sub-article 1 of the Constitution, whenever this court is exercising its jurisdiction in accordance with Article 165, it can grant a variety of reliefs, including reliefs that could be granted in judicial review proceedings. Such latitude is not available in proceedings by way of a constitutional petition, is available by way of a constitutional revision, but not in a judicial review application. On the specific question of whether the President can be sued in his personal capacity during his tenure, our answer is in the affirmative, because it is apparent from Article 143, sub-article 3, that the President or any other person holding that office is only protected from such action in respect of anything done or not done in the exercise of their powers under the Constitution. The rationale for so holding is simple. Assuming in his tenure the President embarks on a mission that is not only clearly in violation of the Constitution, but it is also destructive to the nation, would it be prudent that he should be, would it not be prudent that he be stopped in his tracks rather than wait until the lapse of tenure, by which time the country may have stepped over the cliff? We think in such circumstances, any person may invoke the jurisdiction of this court by suing the President, whether in his personal capacity or official capacity. Whichever capacity he is sued may very well depend on the nature of the violation or the threatened violation, and will certainly depend on the circumstances of each particular case. Having disposed of the preliminary issue, we will now turn to the substantive matter at hand, which is whether BBI steering committee is a lawful entity. The answer to this question can be traced to the special issue of the Kenya Gazette, published on 10th of January 2020. It is in that Gazette, number 264, was issued to notify the general public that the steering committee had been informed. Owing to its import, the question at hand is it is necessary that we reproduce that entire Gazette notice, which we have reproduced here. You will see it in judgment. The bone of contention here is that the term of reference that mandates the committee to propose constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report, taking into account any relevant contributions made during the validation period. As discussed earlier in this judgment, constitutional changes by means of an amendment to the Constitution is a question that is squarely covered by the Constitution itself, and this is Articles 255 to 257 of the Constitution. Article 256 of the Constitution refers to the procedure relating to an amendment initiated by Parliament, while Article 257 speaks to an amendment by citizens themselves or so-called popular initiative. As discussed already, there is no provision for the executive in general or president in particular to initiate proposals for amendment to the Constitution in the name of a popular initiative under Article 257 of the Constitution. Yet, this is what the BBI Steering Committee pretended. As a matter of fact, a constitutional amendment bill has been drawn and is currently before both houses of Parliament for debate purportedly as a bill arising from a popular initiative to amend the Constitution. As Gazette Notice number 264 would show, another body, christened BBI Task Force, had earlier been established prior to the establishment of the BBI Steering Committee. Speaking of this BBI Task Force, in his 6th annual report of 2018, made pursuant to Article 132, Sub-Article 1C of the Constitution, the President notes, inter alia, the Presidency established and operationalized a task force on building bridges initiative, BBI, aimed at addressing the 9 key challenges identified in the MOU, namely ethnic antagonism, competition, lack of national ethos, inclusivity, devolution, divisive elections, safety and security, corruption, shared prosperity, and responsibility and rights. Those are the issues covered in that. It is therefore clear, as concluded above in this judgment, that BBI Task Force, which eventually morphed into the BBI Steering Committee, was the President's and not the People's Initiative. The bill to amend the Constitution is a result of the proposal of the BBI Steering Committee. It is therefore quite clear that what has been presented as a popular initiative to amend the Constitution is in reality the President's initiative, which is certainly contrary to Article 257 of the Constitution, to the extent that the BBI Steering Committee was created to perpetuate what is clearly an unconstitutional purpose, is an unlawful and at any rate an unconstitutional outfit. It is also worth noting that according to Article 132, Sub-Article 4A of the Constitution, the President can only establish an office in the public service on the recommendations of the Public Service Commission. We have reproduced the section as it states. There is no evidence that in creating the BBI Steering Committee, the President complied with this provision of the Constitution. It follows that whichever angle one looks at it, the BBI Steering Committee was an invalid from the very beginning. Having disposed of that question, we now turn to consider the propriety of BBI Steering Committee in preparing and tabling bills in Parliament. The petitioner in petition E16 of 2020 argued that the BBI Steering Committee, as a promoter of the Constitutional Amendment Bill, has no legal mandate to draft legislative bills to implement the proposed constitutional amendments. He argued the BBI Steering Committee continued to drafting multiple bills, and its continued drafting of multiple bills is unconstitutional, since drafting of bill is a reserve of the Honorable Attorney General and Article 261 Sub-Article 4, as read together with the 5th schedule to the Constitution. According to this petitioner, Section 73 of the Constitutional Amendment Bill presents a problem by mandating the Honorable Attorney General and the Law Reform Commission to prepare relevant bills for tabling before Parliament, within a set timeline. He maintained that the legislative bills are a preserve of Parliament under Chapter 8 of the Constitution and no other person. We have considered the petitioner's argument with regard to the preparation of and tabling of bills before Parliament. Article 94, sub-article 1 of the Constitution provides that the legislative authority of the Republic is derived from the people and is vested in and exercised by Parliament at the national level. Sub-article 5 places a caveat that no person or body other than the Parliament has the power to make provision having the force of law except under authority conferred by the Constitution or legislation. A reading of the Constitution is clear to us that only Parliament can enact legislation. However, that does not mean and should not be read to mean only Parliament can draft bills. Its mandate is to legislate or enact, and therefore anybody, including the BBI steering committee, if lawfully established as a promoter of the constitutional amendment bill, could draft bills. Such bills must, however, be enacted by Parliament. This view is supported by the fact that Article 257(2) states that a popular initiative to amend the Constitution should be in the form of a general suggestion or a draft bill. The promoter is required to come up with a draft constitutional amendment bill, which is submitted to the IBC, which then sends it to the speakers of county assemblies and the Parliament for approval or rejection. In the case of a normal bills, they must be introduced before Parliament as required by the Constitution, applicable statutes, and parliamentary standing orders. Consequently, we find that if the BBI steering committee was lawfully established, there would be no constitutional violation in its drafting of bills associated with the implementation of the amendment, the intended constitutional amendment bill. The next point we have to deal with is the BBI process and the compliance with Article 10 and 23 of the Constitution. The petitioner, in this petition again, argued that Article 7, 10, 33, and 35, as well as 8 of the Constitution, were violated, in that the promoters of the constitutional amendment bill proceeded to collect signatures before providing citizens with copies of the BBI task force report, the BBI steering committee final report, and the constitutional amendment bill, all translated in various languages to enable voters read and understand the issues before signing their support, signifying their support to the amendment bill. According to the petitioner, the promoters did not supply reports to the people, did not have the reports translated into Kiswahili, indigenous languages, and Braille for ease of reading. The promoters opted to post the documents on the internet, which the petition argues is not accessible to majority of the populace. This omission, he argued, disenfranchised majority of the voters for lack of information and knowledge of what amendments the promoters were proposing. In response to this argument, the respondents argued that it would have been premature to conduct public participation prior to constitutional amendment bill being submitted to the county assemblies for consideration. In their view, public participation could not be conducted before the initiative had received the requisite support by voters under Article 257(1) of the Constitution and submitted to the county assemblies. It was also argued that the petitioner had neither alleged nor demonstrated that the legislative assemblies did not provide an effective avenue for public participation. It was further contended that the process of constitutional amendment is subject to referendum, which is another form of public participation. The Honorable Attorney General maintained that the BBI steering committee had adduced the evidence of public participation in the form of rallies and public meetings, which we argued the petitioner had not rebutted. In the Honorable Attorney General's view, public participation should also be seen as a continuum starting from the collection of signatures, the 1 million signatures required under Article 257(1), to the presentation of the Constitutional Amendment Bill to the county assemblies and parliament, and ultimately in the referendum. We therefore argue that to raise the public participation objection at this stage is premature. It was also the Honorable Attorney General's contention that the people who signed in support of the Constitutional Amendment Bill are presumed to have read and understood or agreed with the contents of the bill, and therefore the petitioner would not be prejudiced if the process rolled on to the conclusion. The people, we argued, would have the opportunity to vote for or against the Constitutional Amendment Bill during the referendum. On their part, Honorable Raila Odinga and the BBI Steering Committee argued that the scope of public participation under Article 257 is distinct from that required under ordinary legislation. That is, the people themselves who will make the ultimate decision, and that the effect of public participation can only be determined at the tail end of the process. They relied on the annexures to the replying affidavit by Dennis Waweru, sworn on 14th of March 2021, showing advertisements by various county assemblies calling for public participation, to argue that there was adequate public participation. They maintained that the form of public participation would vary from one county to another depending on the circumstances of each county. They also argued that the issue of public participation is premature since the process was still ongoing and the IBC would ultimately conduct its election, civic verification before the referendum. We have considered the arguments by parties on this issue.
This is KTN News.